2020. Matters continuation of a jury trial started yesterday in the sitting session. This is the fifth session of the Dorchester Division of the BNC.
Okay, thank you, Madam Clerk. Mr. McCullough, good morning to you, sir. Attorney Karen, good morning. A.D. Garantino, good morning. And everyone else, good morning. As we resume the trial, Assistant Chief, all jurors are present, correct? All right, so anything we should discuss, Attorney Karen or A.D. Garantino, prior to bringing the jurors out?
We were able to conference last night and agree to admit the body-worn camera video of Officer Frank Woods. My understanding is Officer Woods is not available today, that he left the state for the day anyway.
All right.
I don't want to assume things and say things that I'm not accurate, so I just asked that the sequestration order be in effect during preliminary matters.
Sure. Okay, so all witnesses testifying, please stand by in the hallway, officer, if you don't mind, until we call you in. Thank you very much. All right, Commonwealth have anything to report other than, let me ask about Officer Woods' situation, please.
Yes, Your Honor. So Commonwealth called him after, didn't get a response. I ended up texting him, just letting him know that the trial was carried over until tomorrow. He notified me that he unfortunately was going to be out of the state starting at 6 a.m. this morning. He was unable to come back. He was not going to be one of the Commonwealth's witnesses. He was on my list in case I intended on calling him, but I candidly, and I think from the beginning, I stated it was likely only going to be the one officer who I was calling. I immediately called my sister. I let her know. We agreed to admit his body camera, and I believe she's going to ask Officer Roby questions about it as he's in the body camera footage. And I have no objection to the video being presented that way, and I apologize to the court for not realizing Officer Woods would not be available today.
Okay.
Right. And I asked to be made available. He was on call yesterday, so I do plan on asking Officer Roby just a few questions about Officer Woods not taking it.
About him not being here?
Yes, just if he knows where he is.
What's that? Why is that relevant?
I know it's his day off. I think he's for personal reasons.
But why is it relevant asking one witness about the whereabouts of another witness?
I think it comes down to why Officer Woods just isn't here to testify. Is that he's out of state. He's not here. Okay, I mean, I can bring it back. I think it's one or two questions.
Why is it relevant? Why is it relevant? What witness knows about another witness?
Officer Woods would obviously have information concerning this case.
What more than Officer Roby? What more than Officer Roby? And we have Officer Woods' video footage. What more would Officer Woods testify that Officer Roby's testifying to?
Well, Officer Woods could testify to demeanor, to say that the demeanor was cooperative, that, it could be totally in contrast to the testimony.
Isn't everything on video? Isn't everything on video? Three angles of video, one live witness. I don't think Officer Woods' absence prejudices the defendant. I'm not going to allow the defendant to ask one witness about another witness's whereabouts, okay?
I don't think it's a prejudice issue.
I'm glad you think that. I know your objection. I happen to think it isn't. So that's the ruling, okay?
Okay.
All right. Anything else we need to talk about? All of you're squared away with the video that you wanted to show and queued up and everything. You said that you wanted some time now.
We'll see when it goes. I think I can push a button and then we'll start.
I'm sure A.D. Garantino would offer to assist on the technical aspect of it.
Absolutely.
In front of the jurors. Okay.
Do the parties want this pre-marked as an exhibit?
Yes, it's coming in by agreement as exhibit number
7.
7, okay.
Exhibit number 7, 1 CD body-worn camera footage of Officer Woods.
Okay. All right, ready for the jurors. Thank you, Assistant Chief. Thank you, Assistant Chief. Ladies and gentlemen of the jury, good morning to you all. Thank you very much for your attention. I presume that we don't need to address anything. I do want to thank you for being on time. You were on time as I asked and requested. Any delay this morning, talk about two things about the delay this morning. Number one, it's all on me. Had some issues to address prior to bringing you back in the room, number one. And number two, doesn't affect our schedule. We remain on schedule and continue as I told you we would, okay? So without any further ado, we're going to page in Officer, Assistant Chief, you could grab the officer in the hallway. Madam Clerk, maybe page him. I think he's right outside the doors, and we'll continue. Yes, thank you, Assistant Chief. Officer, you may resume the stand. You can move that microphone so that it's benefits us to hear every word you say, and you remain sworn. Thank you very much. Cross-examination, and hello, cross-examination, Attorney Curran.
Thank you. Officer Roby, you stated that you've been on the Boston Police Force for 28 years.
Yes.
And during that time period, you made thousands of arrests.
I don't believe I said thousands.
On average, how many arrests do you make each year?
I really don't know.
You don't know? You don't know if you made 5 arrests or if you made 100 arrests?
No.
You don't know?
No.
Do you have a title other than officer? Are you a patrolman? Are you a lieutenant, a sergeant, or just
Patrol officer.
patrol officer? Now, on this particular night, on April 25th of 2020, you were in the process at about approximately midnight making a motor vehicle stop.
Yes.
In that motor vehicle stop, were you actually off at that time and your shift ended?
My overtime shift ended at 11:45, and I was starting my regular shift 11:45 till 7:30.
So when you say your overtime shift had ended at 11:45, how long was that? How long have you worked overtime? How many hours?
7 3/4 hours, 4 p.m. to 11:45.
I'm sorry?
4 p.m. to 11:45.
And that was overtime.
That was the first shift, yes.
Okay. So did you have a shift before that?
No, this was my shift.
Okay, so you weren't starting overtime after that. That was your original shift.
Yes, this my original shift is 11:45 p.m. till 7:30 a.m.
Okay, so you picked up, they said you picked up another shift before the 11 p.m. shift. 11 p.m. shift.
Yes, I was ordered to work the shift before 4 p.m. to 11:45.
So actually, it's just kind of a nuance, is that the overtime comes before your regular shift. It's extra hours, correct?
Yes.
Okay, and approximately 8 hours of work?
7 3/4.
A full shift, right?
Yes.
And so, you were alone in your motor vehicle?
Yes.
And you worked the entire shift alone?
Which shift are you talking about? The overtime or
The overtime.
the overtime? I was with a partner.
But the partner wasn't with you at that time?
I was working my regular shift. I was working alone. 12:22 a.m. is when I made the motor vehicle stop.
Right.
My shift starts at 11:45.
And you were working alone at that point?
Yes.
And when you pulled this motor vehicle over, Mr. McCullough, was he present at the beginning of the motor vehicle stop?
I don't believe so, no.
He did not come to your attention until almost the end of the stop, correct?
Yes.
And he was on the sidewalk at that point when you noticed him?
Yes.
And he was filming you. You could tell he was filming. He had a camera up in the air and he was pointing to it.
I seen him with something on his arm, and I wasn't sure what he was doing at that point.
But you recognize Mr. McCullough, didn't you?
Yes.
You know Mr. McCullough, you refer to Mr. McCullough as John, the video man, correct?
Yes.
Or the video guy, correct?
Yes.
And so, at some point, you gave the driver of the motor vehicle a warning,
Yes.
and you had written that out,
Yes.
and it was preserved on a citation,
Yes.
and your motor vehicle stop was completed at that point.
Yes.
And at that point, Mr. McCullough was still on the sidewalk.
No.
When you had handed the citation through the window to the driver, was Mr. McCullough still on the sidewalk?
Yes.
And at that point, you went to return to your vehicle.
Yes.
And at that point, you saw two videos yesterday, correct?
Yes.
You saw your body-worn camera video, correct?
Yes.
And you saw the video that was made by Mr. McCullough, correct?
Yes.
And at that point, when you went to return to your car, Mr. McCullough called out to you. Do you recall that?
No, I remember him stepping up into the front of the motor vehicle as I was walking back.
So you don't recall Mr. McCullough saying anything to you prior to you going back to your motor vehicle?
No, I don't recall.
Now, do you recall yesterday seeing the video made by Mr. McCullough where he says, "Officer, are you through here? Are you done here?" Do you remember that?
No.
So your testimony is you had no conversation with Mr. McCullough, or you didn't hear him say anything to you before you saw him approach the motor vehicle?
I don't recall seeing that on the video, but
You don't even recall seeing that on the video yesterday?
no.
So when you saw him approach the car, that's when you got back out of the car and approached him, correct?
Yes.
And you told him to get back on the sidewalk.
Yes.
And at that point, it was 22 minutes after midnight.
I'm not sure the exact time.
It was between midnight and 12:30 p.m., correct? Right?
Yes.
A.m. in the morning.
Yes.
And you were on Blue Hill Ave.
Yes.
Okay, and Blue Hill Ave is it 2 lanes of traffic?
Yes. Part of it is 2 lanes, and part of it they've cut down to 1 lane and added a bike lane.
Okay, but the area you're in is 2 lanes, correct?
Just prior to that, yes.
No, the area that you're in, that your car is in, and the car that you stopped, that's 2 lanes of traffic, correct?
No, now it's 1 lane and the bike lane. Where they were stopped was at the bike lane.
But there was a full lane of traffic that traffic could flow past your police car and the motor vehicle that you stopped, correct?
Yes.
And one car during this entire time that you were interacting with Mr. McCullough passed by, correct?
I believe so, yes.
And that car wasn't impeded in any manner, correct?
It did slow down and put on its brakes as it was passing by.
Well, you saw the video yesterday, correct?
Yes.
And you say in that video you can see the car slow down and put on its brakes?
There was a car, I believe, when I was going to my vehicle that passed me. He slowed down as it was going past. And then I believe the one in the video is after I got out of the car and was approached John to let him know to go back to the sidewalk.
And at that point you have your lights on your motor vehicle, correct?
Yes.
And at that point Officer Woods had arrived, is that correct?
Yes.
And he had his lights on his vehicle?
I believe so.
And 2 police vehicles on Blue Hill Ave at midnight with their lights on, correct?
I believe so, yes.
And 1 car passed by.
Yes, a car passed by when I was going to my cruiser.
And you also stated that this was a period of time, which there was the pandemic.
Yes,
And that there was a curfew.
yes.
But you had not mentioned, you had not said anything out loud to Mr. McCullough about a curfew that evening, correct?
I believe I did mention it to him.
And in the video, you can't point to any point in the video, either your video or Mr. McCullough's video, in which you said the word curfew, correct?
I wasn't focused on that. No, I'm not sure.
So you weren't focused on the fact that there was possibly a curfew. Is it fair to say that the curfew is not an arrestable event?
I believe it is.
You don't know.
This is the first time they've put out a curfew for a pandemic in my career.
Is another name for the curfew a stay-home advisory?
I believe they do have that as a stay-home advisory as well. Yes.
Actually, that's what it was a stay-home advisory, correct?
I don't know if that's correct.
But you hadn't made any arrests during the pandemic for curfew violations, correct?
Not that I know of, no.
And there were other people out that night, correct?
Yes, there was the people that I just stopped.
And you also mentioned staying 6 feet away, correct?
Yes.
And you didn't mention that at any time to Mr. McCullough, correct?
Yes, I did tell him to back up several times prior to that.
Right, you told him to get back on the sidewalk, correct?
Yes.
But you didn't say 6 feet, correct?
No, I didn't say 6 feet.
And Mr. McCullough did go back on the sidewalk when you asked him to, when he was next to the car, with the women in the car, correct? You told him to get back on the sidewalk, and he did go back on the sidewalk, correct?
Yes, after the second time.
And he never came back into the lane of traffic again, correct?
Yes, he did.
And is that anywhere in the video?
Yes.
He came back into the lane of traffic.
Yes.
He came back to your side of the vehicle.
No, he came back into the street onto the passenger side of my vehicle.
And that's the parking lane, correct?
No, it's not a parking lane.
And it's not the bike lane.
It's a bike lane.
But it's not the flow of traffic lane, correct?
It is a flow of traffic because it's a bike lane.
Bike traffic.
Yes.
And then the entire, okay, at one point when Mr. McCullough goes back to the sidewalk, he asked you for your badge and your name, correct?
I believe so, yes.
And you did not respond to that, correct?
No, I did not.
Yeah. Are you under any obligation when you engage somebody as a police officer to give your badge number and your name?
Yes.
So when he asked you, when you were engaging him, correct, you were ordering him to get back on the sidewalk, correct?
Not at that time when he was asking for my badge number. I was proceeding back to my vehicle.
Well, you had already told him to get back on the sidewalk, correct?
Yes.
And then you were proceeding back to your vehicle, and he was asking you for your badge and your name, correct?
Yes.
And it was at that point, when Mr. McCullough kept following you, that you arrested him, you moved to arrest him, correct?
Yes. After I told him to stay on the sidewalk.
And it's not a crime to step off the sidewalk, correct?
Yes, it is a crime.
It's an arrestable offense to step off the sidewalk.
It's a citation. It's a civil citation.
civil is not criminal, correct?
No, it's not criminal.
And every day we step off the sidewalk, correct, into the street?
Yes.
And every day we see people walking on the street, asking cars for money, correct, in the area of the city. various areas of
Objection.
the city.
Overruled. Yes.
And those individuals aren't arrested for that, correct?
No.
But Mr. McCullough was arrested this evening, correct?
Yes.
And when you went to arrest Mr. McCullough, he asked you what you were arresting him for, correct?
Yes.
And you did not tell him, correct?
Yes, I did.
So you watched the videos yesterday, correct?
Yes.
In the video, at any point, do you recall you telling Mr. McCullough that he was under arrest for disorderly conduct?
I don't recall. I believe I did tell him that he was under arrest for disorderly conduct.
At some point, Officer Woods showed up, correct?
Yes.
And how does he get involved? Did you call him? Is there a call that goes out on the radio when you make a traffic stop for backup of an officer?
No, I didn't call him. I believe he was pulling out of the station. We were a block away from the station, and he seen me stopped with the lights on. I believe he pulled up. I don't believe I called anybody.
So you didn't ask for any assistance at that point?
No.
And so you approach Mr. McCullough, it's fair to say, to make the arrest, correct?
Yes.
And at the same time, Mr. McCullough is still videotaping, is that fair to say?
Yes, he is.
And at some point, you remove your, is it pepper spray?
Yes, OC spray.
And what hand are you holding that in?
I believe my left hand.
And in your right hand, do you have anything in your right hand?
I believe I was reaching for his hand.
At some point, do you, all right, so as you approach him, you have your pepper spray out?
I believe so, yes.
Is there any kind of safety mechanism on the pepper spray?
No, not really.
So the pepper spray is ready to go?
Yes, you just put your finger on it and it discharges.
In your other hand, you believe it's free, there's nothing in it?
It might have been his arm when I was telling him to put his hands behind his back.
So at this point, you don't have handcuffs in your hand?
Not at that point.
So you go to arrest Mr. McCullough with the pepper spray in your hand, but no handcuffs in your hand. You ask him do you state anything to him?
Yes.
What do you say?
I told him to put his hands behind his back.
And he didn't put his hands behind his back, is that correct?
No, he did not.
Okay, one hand has the video in it,
Yes.
and the other hand, where is the other hand?
I believe I was holding his, I want to say it was his right hand or his left hand. I'm not sure which hand I was holding on to.
So at the same time you're holding his hand, you're asking him to put it behind his back.
Yes.
Now, Mr. McCullough is charged with resisting arrest and assault and battery on a police officer. What is the resisting arrest?
Like what was shown in the video, him pulling back and pulling away and backing up and telling me that he didn't do anything and to get off him.
Okay. So Mr. McCullough trying to get away from you, pulling back from you, is a resisting arrest. What is the assault and battery on the police officer?
Is when he struck my hand with his hand and put his fingernail into my left finger.
That is the, so Mr. McCullough, during the resisting arrest portion, he's not fighting.
Yes, he was.
He's pulling away from you,
Yes.
but he's not kicking you.
No.
He's not punching you.
No.
He's not trying to break the hold on you, doing a karate chop, right?
No. No karate chops.
He's just not compliant, right?
Yes.
He's not doing what he's asked.
Yes.
And at this point, you're on the sidewalk, correct?
At that point, yes.
There's a metal clothing box, one of those yellow boxes, is that correct, on the sidewalk?
Yes.
And Mr. McCullough is up against that box, correct?
At some point, yes.
In that area. Okay. So when Mr. McCullough doesn't put his hand behind his back, okay, and this is for the purpose of you putting the handcuffs on, correct?
Yes. After I told him he was going to be placed under arrest.
Then Officer Woods gets involved, correct?
Yes.
And Officer Woods puts his hands on Mr. McCullough also, correct?
Yes.
And together, you are able to put handcuffs on him, correct?
Yes.
And during that process, it's your understanding that you received a scratch to your left ring finger, is that correct?
Yes. His fingernail cut my left ring finger.
And at some point, after that, you put him into the police car, correct?
Yes.
And at some point, your supervisor shows up, correct?
Yes.
And why does the supervisor come?
I called him there
And is the supervisor there because of the use of the pepper spray?
because of the discharge of the pepper spray. Yes.
Is the pepper spray considered a weapon?
It's non-lethal force.
No.
Non-lethal force.
Non-lethal force. But whenever you use non-lethal force, you have to call supervisor in,
You should. Yes.
police procedure.
Yes.
And when there's use of non-lethal force, do you have to complete any forms?
Objection.
So yes, no question? All right, overruled.
You have to complete forms for the.
Use of force. Yes.
And did you complete forms in this case?
Yes.
And did you produce those forms to the prosecution in this case?
I did not.
Now, when your supervisor arrived, you told him what was going on, correct?
Yes.
And what you told him was that he had to arrest John, the video guy, you had to lock him up. John, the video guy, is that the word you used?
Probably.
He didn't tell you your supervisor what you would arrest him on, correct?
I'm not sure. I don't remember if I did or not.
You didn't tell Mr. McCullough what you arrested him on, correct?
Yes, I did.
Did you believe that's in the video?
I don't know if it's in the video, but I know I told him.
And did you, the pepper spray, you got sprayed with the pepper spray, right?
Yes, the pepper spray accidentally discharged to the left of me and went on my arm, my sleeve, and as well as John McCullough's.
And that was an accident.
Yes.
You're not claiming that was an assault battery, correct?
Excuse me?
You're not claiming that was an assault battery on Mr. McCullough's part?
No.
And you got treatment for that?
Yes.
Did you get treatment for the scratch?
Yes.
And what kind of treatment did you get?
They just swabbed it with some alcohol wipes and some iodine, and as well as put a Band-Aid on it.
And who did that?
The EMTs.
And was there any EMT before?
Objection.
Sustained.
I'm not sure.
You stated that Sergeant Brooks took pictures at the police station.
Yes.
They took pictures of Mr. McCullough,
Yes.
and the purpose of that was to gather evidence.
Yes.
May I approach?
You may.
May I show you two photos?
Show counsel. Could you show counsel?
Do you recognize those photos?
Yes.
And what do you recognize them to be?
I believe the photos that Sergeant Brooks took.
And are they photos of Mr. McCullough's hands?
Yes, it appears to be.
Any objection?
No objection.
Exhibit 8 and 9, is that two there, Attorney Karen? Exhibit 8 and 9, Madam Clerk, please.
Exhibits 8 and 9.
Take your time. Thank you.
Officer Woods, Officer Frank Woods, he also had a body-worn camera on, correct?
Yes, I believe so.
May I approach it and may I go side?
Yes.
No, this is what you want to remember.
So, good luck. You can take
I
whatever time you
appreciate
need.
that. I do.
You can take whatever time you need. I know Italy Grantino will be gracious enough with the technical assistance, unless you don't want to Unless you don't want that help, which I can answer. No, I can have the officer help you with that. Okay, all right. Officer Pollard, can you help us out when you get off the phone? Officer Pollard, I know you already did your pull-ups and your push-ups this morning. Can you help us with the media cart in front of the jurors, please? Counsel, as with yesterday, as long as the media cart and the video screen is able to be seen by all jurors, and Mr. McCullough can, Mr. McCullough wants to see, he can stand over by the microphone at the bar there, and you can inquire from wherever you want to stand, and if you want to have the witness step down, you can ask that as well. I think that's fine right there. And all jurors see it? Looks like all jurors can see it, okay. Does that work for you, Attorney Karen?
Yes, I just want the officer to be able to see it all.
From the stand, or you want to step down? All right. Officer, just stand right next to the car like you did yesterday. Take a look at the video. And just both of you need to keep your voices up because you're away from the microphone, although they're in the room, as you know. Just make sure you're audible enough, okay?
Your Honor, if I may just approach to assist.
Sure. Yes.
Earlier, the audio was okay with the officers.
Say it again.
Is the audio okay?
To hear him, you mean?
Yes.
I think as long as he just speaks up, I think we should be able to pick it up. That microphone on the DA's table works as well, and so that's fine.
That just shot out of it, 18 seconds of this video. Do you recognize those?
Attorney Karen, this is Exhibit 7, right?
Yes.
Okay.
I recognize the car stop.
Yeah, well, recognize it. The video to be, the same scene as the
Yes.
And in the video, can you identify who's in the video yet?
I believe that's myself and the defendant, John McCullough.
And at this point, you're trying to effectuate an arrest, Mr. McCullough?
Yes.
Mr. McCullough has his, camera in his hand, take this one, right?
Yes, I believe so.
At that point, it is in your handcuffs and
it's on his arm.
Take your time.
At that point, it's absolutely nothing in the arrest process.
Yes.
And he has his hands on his McCullough also.
Yes, I believe it was right on.
Thank you.
You done with that?
Yes.
Okay. Assistant Chief, can you help us move the monitor back to the corner of the room, please? Appreciate that. She's got it totally under control. Thank you, Officer P. Thank you, Assistant Chief. Counsel, you may inquire.
Officer Rowley, we had an opportunity to see the video, body one camera of Officer Woods. In that video, you have your left hand on Mr. desk, pushing him back, is that correct?
I believe so, yeah.
And on a scale of 1 to 10, that force that you're using to push him back, what would you say on a scale of 1 to 10, that force that you use?
Probably maybe 6, 7.
And together with Officer Woods, you both were trying to put Mr. McCullough's hand behind his back, correct?
Yes.
And in that process, can you tell us on a scale of 1 to 10 what force you used?
I just said about 6, 7.
Also, two separate uses of force, correct?
I
I don't quite follow, but you can ask the question. I don't quite follow the gauge, the range, the parameters there, but
So there was two uses of force, correct? Once when you pushed Mr. McCullough back on the sidewalk, and then you forced his arms behind, correct?
as well as giving him the verbal commands to put his hands behind his back.
But that's not a use of force, right? The verbal command.
Yes. That's command presence.
So you consider that force.
They do consider that force, yes.
I have no further questions, thank you.
okay, redirect.
Thank you.
Okay.
Officer, why in that body camera did we see you holding the defendant's sweatshirt?
I was holding his jacket and giving him verbal commands to put his hands behind his back that he was going to be placed under arrest.
And at that point, why were you holding him by his arms, for example?
He was pulling away from me.
Okay. And what would you describe his demeanor at that point in the body camera we just saw and we saw yesterday?
Agitated and not wanting to be placed under arrest.
Okay. And just turning to this sort of sliding scale, 1 to 10, that was just brought up. You stated you used 6 out of 7 force for both handcuffing him and attempting to get his arms, right?
Yes.
And why did you use that amount of force?
It was the amount of force that he was pushing back on.
And what type of force do you typically use when you effectuate an arrest?
It depends. It depends on the defendant, and it depends on if they put their hands behind their back. Then 1 to 2 and hardly any force at all. And if they're resisting, then usually goes up to, I guess, 6 to 8 if we're using the sliding scale.
And there's been talk about pepper spray or OC spray. What is that?
It's use of force contingency that the Boston Police Department uses, and it's like a cayenne pepper type OC spray.
Okay. And are you trained to use that?
Yes.
And what are you trained on?
We're trained to use it when people are non-compliant and when they're attempting to resist arrest and to fight to gain control.
Okay. And why are you holding the pepper spray in this incident?
Because John was showing signs that he wasn't going to be arrested and placed under arrest.
And do you remember at what point specifically you took the OC spray out at?
I believe after I walked up on him and was telling him to put his hands behind his back.
And did you use the pepper spray intentionally?
No, I did not.
And it was an accidental discharge.
Yes.
Okay. And in an officer with body camera, we see him come over. Why was he needed?
Because John McCullough was resisting arrest and not putting his hands behind his back.
And how exactly did he assist you in that?
He gained control of his right arm and well, I was able to gain control of his left arm and cuff it and cuff his right arm.
Okay. And briefly, just starting back to the OC spray, my apologies. Where were you treated by EMS for that OC spray discharge?
At the station.
Okay. And why was the defendant not treated, if you remember?
He refused EMT's assistance.
Okay. And looking at officer with body camera, how many cars, if you notice, did you see pass by?
2.
And you did observe cars on the road?
Yes.
Okay. At the beginning of your cross, we're asked about your 2 shifts back to back. How often do you work 2 shifts back to back?
Now a lot more often.
Okay. And when you say that, how much?
Probably 3 to 4 times a week.
And is that something that's been common over your 28 years as Boston police officer?
Yes, now it does.
Okay. And how does that affect your work at all when working 2 shifts back to back?
It's still the same job. You're still doing the same thing. You know? So it affects you, I guess, when you're tired and usually later on in the shift at about 5, 6 in the morning, you start to get tired. And
Okay. This was just around midnight, right?
yes, it was just the start of it.
And on cross, you mentioned you previously know the defendant.
Yes.
How do you know that?
Sustained.
If we may approach that.
Okay. Okay, so the question on trust dissemination, no, and has John the video guy. What's the answer you would expect coming from this officer?
I just simply tell us the testimony of previous interactions, how he's acted in the past, his demeanor, as well as him on whether or not he knows him.
Well, what do you say to that? Did you ask the question, do you know him, right? He said yes. You know him as John the video guy or the movie guy or filming guy, right? He said yes.
Because it was in the video, I'm not going into anything in afterwards that he said to his supervisor. I had to lock up John videos.
All right, he did say it in the video. What else do you want to know?
I just want to know how exactly he knows him, what previous interactions he's had with them, all interactions have gone this way.
No, it's objection sustained.
I may just have one moment, Your Honor.
Take your time.
So there's been some talk about this being the beginning of the pandemic. What policies were implemented by the Boston Police Department as it relates to a curfew?
It was implemented by the governor as well as the mayor.
And what were you trained to do, though?
Okay, that objection is overruled. What's the next question?
What were you trained to do as an officer as it relates to that governor's ordinance?
To advise people to stay at home and to be off the street.
Okay. And were you trained on what to do in this situation?
No.
Okay. And how did you personally treat these interactions with people being out past time?
In this case,
Generally.
sustained.
Nothing further.
Okay. Anything based on those questions, Attorney Karen?
Yes.
Okay.
Officer Rowley, you approached Mr. McCullough to arrest him with only your pepper spray in hand, correct?
I believe so. I believe that was it.
Okay. Officer, you may step down. Thank you very much. Thank you. Commonwealth, have any further witnesses?
Come on, rest.
Okay. Ladies and gentlemen, you've heard testimony for an over an hour. I'm going to give you the morning break so we can get that in, and we'll see you shortly. Thank you very much. This is the Chief. Okay, thank you, officer. Any motions from the defendant at this time, Attorney Curran? Attorney 88 Granatino, can you kindly just rewind Officer Wood's body worn camera footage and press play? I want to see the first few minutes of it, please. You can just do it right here, and then I'll hear from the parties. Thank you. Okay. Attorney Karen, I'll hear you on your motion for required finding of not guilty.
I just suggested, but I don't know if else wants to watch, the other video, only because the video really shows the beginning of the arrest process. The other two videos show the faces with the disorderly. Shows how Mr. McCullough is positioned and what he does in cars going by.
Okay. Attorney Grantino, can you help me out with the technological endeavor? And we'll put in exhibit number 1, please. Assistant Chief, I don't know if Officer Roby's in the hallway. He's welcome to stay. I didn't mean to tell him that he had to leave, so I just thanked him for testifying, but I thank all witnesses, so he's welcome to come in and listen to argument. Thank you. Thank you. Madam Clerk? You have Attorney Karen write the case name on this file, for the filing.
You gotta give us a judge. She's nothing to arrest right now. No. She can drive, but she has to be in the front seat. You guys need to put your feet on the floor. Because you went in the right hand lane and you go on left. And that lane is a light lane. It's not supposed to be driving. See right here? See how it's off?
Yeah, but what I was trying to tell you is I was gonna turn and we changed our mind. That's why I ended up going right.
I don't think you still can drive. You can't turn from that lane. That's why I explained it to me. Okay, so listen, it was $105 for the wrong lane. Your speed was 40 and a 45. The whole city is 45 miles an hour. Okay? I gave you a warning for that as well. All right? It would have been $305. All right? I gave you a warning.
Thank you, appreciate it.
And that would have been on your license. Okay? That would have been on your license for the citation. Step onto the street. Step on the street. Step onto the street. Step onto the street. All the way along here, okay? Step onto the street. You understand, you know? You understand? I think the fence. Take the fence. Right, yes. Chapter 48, section 98, take the fence. Step onto the street. Now I'm gonna tell you again. Let me see. Yes.
to find that there is insufficient evidence in the light most favorable to the Commonwealth to carry their burden. The first charge, the disorderly conduct charge, the jury instruction requires that the Commonwealth prove that the defendant was either engaged in fighting, threatening, or engaged in violent, tumultuous behavior, or created a hazard or physically offensive condition by an act that served no legitimate purpose of the defendants. Mr. McCullough was on the sidewalk expressing his First Amendment rights to free speech and to videotape police officers in the process of their duties. The Commonwealth must prove that his behavior or his actions were reasonably likely to affect the whole entire public, not a particular individual, but the public at large. And the Commonwealth must prove beyond reasonable doubt that the defendant either intended to cause public inconvenience, annoyance, or alarm, or recklessly created risk of public inconvenience, annoyance, or alarm. It appears from the testimony of Officer Roby that Mr. McCullough is arrested for not obeying his command to get on the sidewalk. This is not disorderly conduct. There is a criminal violation of failure to obey a police officer when you're in a motor vehicle, but there's no requirement to obey a police officer to get back on the sidewalk. And that in order for it to rise to the level of disorderly conduct, it has to be really violent, tumultuous behavior, threatening, frightening, engaging behavior. The Commonwealth may argue that Mr. McCullough's behavior became exasperated or agitated or higher, but that was not the disorderly. The disorderly, there was no fighting. The officer said that there was no kicking, no punching, no attempt to create a violent, tumultuous situation. Mr. McCullough's behavior in filming, videotaping the officer and asking for his badge and his name did not reasonably likely to affect the public at large. You saw in that video one car go by. I don't think it changed its speed, and it was in the passing lane. It's not something that obviously had an effect on people. Any kind of police incident can have an effect on traffic. If you're watching, slow down traffic. In this situation, there was really nobody on the street, nobody on the sidewalk, nobody in the vicinity. It wasn't for the purposes of causing a scene, a public display. And that his intentions were to put the public at risk or to cause any inconvenience or annoyance. I think that what Mr. McCullough was doing in approaching the car in his video, the YouTube video, that he asked the officer if he's done there, and he goes up to the car and he engages the people in the car to find out if they were treated appropriately. I don't think it shows an intent to cause public inconvenience, annoyance, or alarm. You can see the demeanor of the female in the driver's seat. She's smiling, she's agreeing with Mr. McCullough, and then the officer comes back and she's told to leave the scene, to move out, and she does so. I don't think it's anywhere near what's necessary to prove the charge of disorderly conduct. The second charge of resisting arrest, which the officer states that he is not going to arrest him because he's disorderly. I asked the officer point blank, what is the resisting arrest? He states the resisting arrest is pulling away from me. He's not complying. He's not agreeing to be arrested. Well, it's a legal term. It's a term of art. A person commits a resisting arrest when they attempt to prevent a police officer from effecting arrest by threatening them or using physical force or violence against a police officer, or by any other means which creates a substantial risk of causing bodily injury to such police officer or another. And how I read that is that in this case, Mr. McCullough is not threatening the officer. He's not using physical force or violence against the police officer. You can see when the police officer approaches him, he continues to video with one hand, and then he keeps a stiff arm with the other hand. He's asked to put his arm around his back. He doesn't do so. So in not complying, he's going to suffer the consequences, and he's going to be forced to put his hand behind his back. But he's not using force on the officer. It states here that by using other means which creates a substantial risk of bodily injury to such police officer or another. I read that to be the type of situation where someone runs and the officer has to chase them in traffic or has to put himself at risk, causing the officer himself to be at risk. In this situation, Mr. McCullough does not think he should be arrested, so he's not going to agree to be arrested. But he's not doing anything of force or violence against the police officer. He's just not complying. Again, that doesn't rise to the level of a resisting arrest, and I don't believe the Commonwealth has come close to proving to their burden of proof, and in the light most favorable to the Commonwealth, that they haven't proved that there's any physical force or violence on the part of Mr. McCullough, or that he put the officer at substantial risk of causing bodily injury to the officer. And then the assault and battery charge that the officer states
Let me pause you on before you make that argument so I can ask the Commonwealth a question about the A and B. Are you moving on an intentional or reckless assault and battery on a police officer?
Intentional, Your Honor.
Go ahead, Attorney Karen.
Okay, and I think that is even more so that moving on intentional assault and battery on a police officer, that the touching was either likely to cause bodily harm or was offensive. I think that the touching was inadvertent in terms of the officer is now pulling his hands back to make the arrest, and in the process, at some point, he becomes aware that he has a mark on his finger and attributes it to Mr. McCullough's fingernails. However, the facts of the case are not that Mr. McCullough touched him in a manner that he was intending to touch him, and that touching was likely to cause bodily harm. And when you look at the injury that did result, it is a nick to the finger, and I don't believe, based upon the evidence that was received, that it's clear that there was a scratch, an intentional scratch, that at some point in placing the handcuffs on Mr. McCullough, the officer got a nick on his ring finger. I don't believe that enough evidence has been put in that the defendant approached the officer, intended to touch the officer, and that touching was likely to cause bodily harm. It's the officer that approached Mr. McCullough, intended to touch Mr. McCullough, and as a result, there was a very minor scratch to the officer, which I think is probably between all the items that the officer had in his hand, the handcuffs, the phone, the spray can, the ability to attribute that nick on his finger was caused by a intended touching when the officers had their hands on Mr. McCullough and were forcefully using handcuffs to control him or to arrest him. I think it does not rise to the level where the Commonwealth has met its burden to prove that Mr. McCullough touched Officer Roby. He intended to touch Officer Roby. I think it's clear that he didn't intend to touch Officer Roby, had wanted nothing to do with Officer Roby, and it was not acting in a manner where he intended that touching to cause bodily injury or harm to the officer.
Okay, thank you, counsel. I'll hear from the Commonwealth on all three counts.
Thank you, Your Honor. Your Honor, Commonwealth asks that you deny my sister's motion, turning to the first charge, disorderly conduct. I would suggest the Commonwealth has presented sufficient evidence for this charge to go forward to the jury today. Your Honor, you saw on the body camera footage as well as in the defendant's video, you can see that Officer Roby is engaged in a motor vehicle stop, and the defendant then appears in the video. And I would suggest, just turning to the elements of the charge of disorderly conduct, that the first element has been shown. The defendant created a hazardous or physically offensive condition serving no legitimate purpose.
What's the hazardous or physically offensive condition?
And that is, Your Honor, the fact that Officer Roby is conducting a motor vehicle stop. After that motor vehicle stop is completed, he gets back into his motor vehicle and then notices the defendant approach the driver of the motor vehicle, coming within at least 1 foot of contact with her. He subsequently gets out of his cruiser.
Pause for a second. Why is that what you just described? Fighting, threatening, violent, or tumultuous behavior, or creating a hazardous or physically offensive condition?
I would suggest that creates a hazard or physically offensive condition, Your Honor, coupled with the fact that the woman had a blinker on. She was trying to leave, and she could not leave because the defendant was blocking her. He was in her way. Officer Roby exits his motor vehicle, has the defendant get back on the sidewalk, and you can hear Officer Roby say, "You're all set, you can leave, you're free to leave," and she's finally able to go. If it wasn't for the defendant standing there blocking her, she would have been able to leave. But in this point, Your Honor,
But we saw the video of her reaction. The video wasn't, "Get out of my way, officer, this man is stopping me from leaving into the street." Her reaction was quite different. In fact, I took note of the fact that although she had just been given a huge break by a Boston police officer, she agreed with the defendant that he was rude or he was whatever she was saying regarding the officer's stop of her. It was in a pleasant, conversant tone. Am I right? Did I miss something on that
It was,
video?
Your Honor. However, she is a young woman, and a stranger approached her in the motor vehicle. Who knows what her feelings or thoughts were?
How did she present?
She presented outwardly okay, but Your Honor, I would suggest that she could have been reacting in a way. Who knows if she was actually fearful or if she was just trying to go along with the situation, where someone who she doesn't know approaches her with her motor vehicle window down at 12:20 in the morning, Your Honor.
You believe that was hazardous or physically offensive?
I would, Your Honor, and I would suggest that Commonwealth v. Bosk, B-O-S-K, is pretty on point here. It says that...
Tell me about Bosk, because I read that too. I read that it's an individual standing in traffic lane, forcing vehicles, plural, to pass around them. Tell me about that case.
Yes, Your Honor, and that's essentially a summary of the facts. I don't have the exact case printed out. However, I would suggest that this case is similar to Commonwealth v. Bosk, where Miss Maldonado, who was the driver of the vehicle that was pulled over, she wasn't able to get around the defendant. She was in her parked position still. The defendant approached her. She couldn't get out of her position because the defendant was alongside her vehicle, and therefore, similar to Bosk, she was unable to pass around him, and in Bosk as well. The defendant was debating with police officers, refusing to return in that situation to his car. But I would suggest here, very similarly, the defendant was refusing to get back on the sidewalk. He was confrontational. He was creating a hazardous scene. And that scene was
that point wasn't confrontational?
No, because after the officer got out of his cruiser, he did step back.
And remind me about the video I saw. We don't have to rewind it back. I'll accept your representation. Remind me what was blocking the three women in the car from just driving straight out. Was there a cutout in the street?
I believe there was a bit of a cutout, Your Honor.
Is that your recollection? We can rewind it, I guess, and take a look, but go ahead with your argument.
So I would just suggest, Your Honor, for those reasons, the fact that the defendant was blocking her path, he created a hazardous condition. And you also saw in Officer Wood's body camera, we only saw one car pass during that stop, and Officer Roby testified to the fact that that vehicle did have to slow down in order to pass. There was other vehicles on the road, as we saw in Officer Woods. I think I counted at least 4 cars that went by, Your Honor. So there were other cars that could have been...
When all this stuff went down, Mr. McCullough made the decision to move back or continue to step back. He was on the sidewalk / out of the street at that time.
At that point, yes.
When were the cars slowing down? The officer approached the defendant walked backwards, and the conversation ensued. But when were the cars trying to avoid him? I didn't see that.
So there was one car,
They're trying to avoid who? Officer Roby or Mr. McCullough?
Mr. McCullough. And we
I
can
didn't see that.
We can play the video. And
Let's
Officer
do
Roby
it. Show me the
testified.
video.
And in body camera, Your Honor, does not show everything. So Officer Roby,
Sure.
I would just also defer to his testimony.
All right. I credit the officer's testimony on that. I want to see the video where a car has to avoid Mr. McCullough. And so pause it there if you don't mind. And you can see it on the laptop. What's prohibiting that vehicle from driving straight, whether that's a bike lane or?
There's a little bit of.
I see it. I see it. But where?
That was the kind of closer to the sidewalk then, and not in the lane. We had to prohibit them from cutting out because they wouldn't have as good of a ability.
Well, but they don't have to take a right angle left to get out. If they wanted to get away from Mr. McCullough, they could have just turned the steering wheel and driven in a slightly angled.
Condition, Your Honor, where that driver of the vehicle could hit Mr. McCullough who's standing in the middle.
All right. Okay. Now show me where the cars are trying to avoid Mr. McCullough.
Grant permission to pass Morrisville where the defendant's name is vehicle.
Just leave it for there if you don't mind.
Yeah, but what I was trying to tell you was I was gonna turn and we changed our mind, that's why I ended up doing the break. I don't think you took that drive, you had a turn for that way. I already have a drive. That's why I explained it to me. Okay, but it wasn't $105 for one lane. It would be for 40 and the 25, the whole city is $25 an hour. Okay, I gave you a warning for that as well, all right? It would have been $305, right? I gave you a warning.
Thank you, appreciate it.
And that would have went on your license, okay? That would have went on your license for the citation. Step on the street. Step on the street.
How's that, Tommy?
Step on the street. Step on the street.
Can we agree the car just drove by Mr. McCullough in the center lane?
They did.
And can we agree that vehicle didn't look to have to avoid Mr. McCullough?
From the view of, we saw of it, I would agree that it's not, but we don't know if it slowed down before it came into.
All right. Are there more vehicles that you're referring to, or is that the only one?
That's the only one.
Can you continue to run it for me? Just for another few seconds. All right, thank you. Go ahead, you can continue your argument on the count one.
Thank you, Your Honor. Your Honor, so I would just suggest, as you saw a motor vehicle pass, Officer Roby testified that he saw that motor vehicle slow down. Unfortunately, again, body camera doesn't capture everything, Your Honor, and I would submit to you that there has been enough evidence as it relates.
Let me pause you by saying the body camera doesn't capture everything. Are you implying that the officer was referring to yet a separate and distinct other vehicle?
No, Your Honor, I'm suggesting
What do you
that.
mean when you say the body camera doesn't the body worn camera doesn't capture everything? What did we miss?
Yes, Your Honor. So I would suggest that the body camera was facing forward when we saw the motor vehicle go by. We don't know if it slowed down behind, and Officer Roby testified that the motor vehicle did slow down.
I see.
So,
Slowing down is different than passing around, right? I mean, is it? You can't answer that question?
it is.
All right. So Bosk talks about passing around. right?
Yes, but I would suggest that the vehicle here had to slow down potentially to pass around officer.
All right. What else on count one?
Your
I
Honor,
credit the officer saying that a vehicle slowed down when passing Mr. McCullough. What else on count one?
so I would just echo, Your Honor, and the Commonwealth's main point here is that Ms. Maldonado, the driver of the motor vehicle, again, she wasn't able to pull out safely. Yes, she was engaged in conversation with the defendant, but if she took off, who knows what the defendant would have done? He wasn't on the sidewalk. She could have potentially hit him. At that point, we didn't know what the defendant was thinking, where he was going. He was in the middle of the road. So I would suggest a hazardous situation was present. Ms. Maldonado at that point was unable to leave, and his defendant's behavior created a public inconvenience or annoyance or alarm under the elements of the charge of disorderly conduct, Your Honor.
All right.
As it relates to resisting arrest, Your Honor, I would also ask that you deny my sister's motion as it relates to that count, Your Honor. The first element here is that the defendant prevented or attempted to prevent police officer from making arrest. Officer Scott Roby was in full uniform, in a police cruiser. His lights were going blue. It was very clear, Your Honor, that he was an officer engaged in a motor vehicle stop at the time that the defendant inserted himself onto the scene of this incident. He was acting under his color of duty, and he's asked the defendant multiple times to get back onto the sidewalk. And he initially complied. He did get back on the sidewalk, but as he followed along the road on the sidewalk, he then gets back down, disobeying the officer's command, again, creating a substantial risk that something could have occurred. At that point, the officer, as you heard him testify, was placing him under arrest for disorderly conduct. The defendant knew he was under arrest. Officer Roby stated multiple times, "You're under arrest. Put your hands behind your back. Put your hands behind your back. Put your hands behind your back." The defendant continued to walk backwards, hold his arms, as you could see in the video. One of them pinned to his side, not complying or putting it behind his back, holding the other one up while he was still recording the officer. He knew at that point, Your Honor, he was under arrest, and he continued to resist arrest, which could have created a substantial risk causing bodily injury to the officer.
Talk about that third prong. I'll give you that the officer was acting under the color of his authority at the time. He was clearly a Boston police officer. Lights were flashing. He was dressed in full Boston police uniform. The defendant knew at the time the officer was acting as a police officer under his color of his official authority. Tell me about the defendant resisted either by using or threatening to use physical force or violence against the police officer or another person, or by using some other means which created a substantial risk of causing bodily injury to the police officer or another person.
Yes, Your Honor. I would suggest that the defendant in this case before us today was using other means which created a substantial risk of causing bodily injury to Officer Roby, which ultimately resulted in his injury. I would suggest, Your Honor, that he did get a scratch, and that his behavior, his demeanor, the fact that he was non-compliant, he kept backing away from officers, he kept his arms pinned down, one of his arms pinned down by his side while the other was holding, could have created worse injuries for the officer. In fact, a second officer had to arrive on the scene just to get the defendant under control, just so that they could put handcuffs on him, Your Honor. I would suggest that the defendant's actions could have created a worse situation, and it did in fact create a substantial risk of injury to the police officer, Officer Scott Roby, while he was engaged in his duties. And I would say that the defendant did this knowingly. He knew he was preventing an arrest, Your Honor. It was very clear he was placing him under arrest for disorderly conduct. We saw 3 different videos showing that arrest. He was non-compliant. He was confrontational. He was pulling away from him, and candidly, worse injuries could have resulted. But he did have a scratch. He was treated by EMS as a result of it due to this incident. And this isn't the alleged assault, but there was OC spray that was discharged for his eye, into his eye. We saw photographs where there was spray in his eye. So just overall, it was a tumultuous situation, Your Honor, and there could have been worse injuries. So I would ask that you deny my sister's motion as it relates specifically to the resisting arrest charge. And lastly, Your Honor, the assault and battery on a police officer charge. Again, I would ask that you deny my sister's motion. Just turning to the elements, the defendant touched Officer Scott Roby. Although we don't see it again in the body camera just because of the way that it's positioned, we don't actually see him grab Officer Roby's arm per se, but Officer Roby did testify to the fact that he did grab his hand. It wasn't accidental. It wasn't incidental conduct. He was trying to effectuate an arrest, Your Honor. And during the course of that arrest, he grabbed at his arm, and that caused a scratch. And the defendant, again, knew he was a police officer. He knew he was engaged in the performance of his duties. He saw him pull over the motor vehicle, or he saw him engaged, at least, with that motor vehicle. Saw Officer Roby hand back the driver's permit and registration, as well as the passenger's license. So he knew that he was engaged in the performance of his duty. Again, there was injuries to the officer in this case. There's photographs of those injuries. Specifically the injury, the cut to his hand, Your Honor. And I would suggest again that there's been sufficient evidence presented in the light most favorable to the Commonwealth for all three of these charges to go forward to the jury.
Okay, thank you, counsel.
Just be clear on the second one on the resisting arrest.
Yes.
The Commonwealth skips the second prong, goes right to or using by other means. The second prong of resisting arrest is by using or threatening to use physical force or violence against a police officer or another. I think it's clear that the Commonwealth is saying that he didn't do that, but he used other means. And then they fall back on the other means being he didn't comply. I think that the rationale behind the resisting arrest is that someone can't use force, they can't use violence against the officer in the officer effective arrest. And if they create a situation where the officer could be substantially at risk of causing bodily injury, and I go to the example of the individual who's stopped for an OUI on the expressway and decides to run in traffic, or causes the officer to place himself in a position where he is in substantial risk of bodily injury. Again, Mr. McCullough did not comply. That is what happened, and so the officers used force on him to make him comply. I don't think it put the officers in substantial risk of bodily injury by the fact that he did not comply.
Okay, thank you.
If I just may briefly.
Go ahead.
So, Your Honor, Commonwealth reading is that it's not a one or the other, it's an either or situation. So it's either there was threatening to use physical force or violence, or by using some other means, creating a substantial risk of causing bodily harm. It's not one or the other, and one's not weighed more heavily than the other. It's an either or situation, Your Honor. Here we have the latter that is listed in the jury instructions, but it's still given the same weight as the first one on the list.
Okay, thank you. As you both know, the court must review this evidence and reasonable inference thereof in the light most favorable to the Commonwealth. That's the Commonwealth v. Lattimore standard. And I have to determine whether any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. That's Commonwealth v. Powell. The relevant inquiry here is whether the evidence would permit a jury to find guilt, not whether the evidence requires such a finding. It's Commonwealth v. Guy. And I am making all reasonable inferences from the evidence in resolution in the Commonwealth's favor on the Grandison. Hold on. So referring to count one, the disorderly conduct. Again, I credit the officer's testimony as to what he saw. We saw everything he saw, essentially. And I don't believe that anything that he testified to is substantially different than what we saw with our own eyes on the video. That's not what this is about. Intent is key in these three allegations. The Commonwealth v. Boss case, I find, is significantly different. Mr. McCullough was standing in that right-hand lane, whether it be a bike lane or whether it be a cutout, and maybe a car did try and slow down approaching Mr. McCullough. But the video shows, consistent with Officer Roby's testimony, the video shows the car in the lane, wasn't screeched, wasn't a wild attempt to avoid Mr. McCullough. The statute specifies that the defendant must be found to show that he's engaged in a fighting or threatening or engaged in a violent or tumultuous behavior or created a hazardous or physically offensive conduct by an act that served no legitimate purpose for the defendant, and that the defendant's actions were reasonably likely to affect the public, and that the defendant either intended to cause public inconvenience, annoyance, or alarm, or recklessly created a risk of public inconvenience, annoyance, or alarm. After consideration of the evidence of count one in the light most favorable to the Commonwealth, no rational trier of fact could find the essential elements of disorderly conduct. Turning to count two, assault and battery on a police officer. Again, intent is paramount here. That's what I have to consider under the law. And again, I credit Officer Roby in his testimony. I have to find that the defendant touched Officer Roby without any right or excuse for doing so, that the defendant intended to touch Officer Roby. That touching was either likely to cause bodily harm or was done without his consent, that Officer Roby was a police officer, the defendant knew Officer Roby was a police officer, the officer was engaged in the performance of his duties. I also have to find that the defendant consciously and deliberately intended the touching to occur, and that the touching was not merely accidental or negligent. That language is included in the jury instructions / statute. The intentional branch of this crime requires an intentional touching and not merely an intentional act resulting in a touching. Commonwealth v. Burke case. After consideration of the evidence on that charge in the light most favorable to the Commonwealth, I find no rational trier of fact could find the essential elements of assault and battery police officer beyond a reasonable doubt. Again, continuing to credit the officer's testimony. On count three, or the third count, which is resisting arrest. Resisting arrest requires that the defendant's actions by using some means created a substantial risk of causing bodily injury to the police officer or another person. And I credit Officer Roby about the injury. My review of the video and the testimony does not lend to the intent for that prong of resisting arrest to be satisfied. My consideration of that evidence in the light most favorable to the Commonwealth, I find no rational trier of fact could find the essential elements of the crime beyond reasonable doubt. This is a troubling matter, and it's troubling in that The evening started off with an officer couldn't have been more polite to a young Massachusetts driver, newly licensed or using her learner's permit. Gives the young driver a break, financial break, and a break on their license going forward forever. The toxic atmosphere of the pandemic no doubt played a part in the events of that evening. We shouldn't have got to that. And I'm not trying to get into Mr. McDonough's mind. I'm not trying to get into Officer Roby's mind. But probably both individuals, if they could rewind the clock, which is impossible, would not want this case to go to trial for one reason or another. This is not about whether Mr. McCullough was being a bad person or if Officer Roby was being a bad person. This is not what this is about. Based on that, the defendant's motion for required finding of not guilty on all 3 counts is allowed. You can discharge Mr. McCullough, Madam Clerk.
All right, Mr. McCullough, if you please rise. After full hearing and argument, the court has allowed the defendant's motion for required finding of not guilty on the 3 remaining charges, counts 1, 2, and 4. Having entered that finding of not guilty, sir, you are hereby discharged.
Officer Roby, thank you very much for your service to the city. Mr. McCullough, good luck, sir. Take care. All fees are waived.
All fees are waived.
Thank you, counsel, for a professional and well-tried case. I do appreciate that out of both of you. Thank you very much. Good day, everybody.